Yes, Mr. Glenn, good morning.
Good morning, Your Honor, and good morning, Your Honors. My name is Thomas Glenn. I represent Michael Clarke. This is a case that was filed originally in the appeals court. Your Honors have chosen to hear it. This began with the felony convictions for Mr. Clarke in the district court, in the Dorchester District Court, two counts of distributing controlled substances, felonies in school zones. And it involved a plea on that charge, which was known as a breakdown, where he received a lesser sentence than the mandatory minimum. And at that time, Mr. Clarke had counsel, and he went through with the plea and did about 3 months. Thereafter, I filed a motion this past year in the Dorchester District Court, and pursuant to Strickland and Padilla, stating that the plea was should be allowed to be withdrawn, as Mr. Clarke was not afforded effective assistance of counsel regarding warnings that were given to him or were not given to him by his counsel at that time. At the time, I did include a affidavit of counsel. That affidavit of counsel stated that she was not aware at the time of the plea that Mr. Clarke was not a citizen of the United States.
So you're suggesting that it's counsel's obligation to determine whether or not their client is a resident of the United States, citizen of the United States?
Yes, and part of a larger context, and to also advise him. I would say both. He has a duty to advise, I would say, under Strickland and Padilla. But beyond that, I would also say he also had a duty to inform himself.
But the lawyer's appointed to represent someone, and you look at their record, and they seem to have been around for a while, and they don't say, oh, by the way, I'm not a citizen. The lawyer's first question, are you a citizen of the United States? I mean, so this is part and parcel of what a lawyer needs to do, is inquire into the citizenship and immigration status of anyone they're appointed to represent.
Yes.
Okay. No burden on the defendant to sort of say, by the way, I'm not a citizen.
I would say the burden is on counsel
Okay.
to enter into those discussions, certainly before any plea is made to a felony.
Counsel, in any case, already has certified at this point, right, as do the judges, that they're giving general consequences warnings. That's already a duty, apparently, or at least counsel appear to be filing those green sheets saying that they've done that.
Giving general warnings.
Mm-hmm.
Yes, I believe that's true. I think Padilla goes a little further than that.
I understand that. I wasn't suggesting that it doesn't. I was merely saying that it doesn't seem to be a new kind of burden. It's just a more refined one. So in general, you have to tell, and then you affirm that you've given immigration warnings generally, and then you're suggesting that under the Strickland-Padilla, or Padilla, I'm not sure how it's pronounced, analysis, there should have been even more than that. Not just general warnings, but and, in your case.
Yeah, I do. And as an aside to that, I'm not sure exactly what you're saying. If the green sheet itself that was signed by the defendant, would that, I'm sorry, you want to prove that?
I'm not suggesting that establishes that anything about what the specific advice was given that individual status as a citizen or not, and that individual's particular crime to which he's pleading, and whether that under the immigration regime as compared to the state regime would have the result of deportation. I'm not suggesting that.
Okay.
My question is more to clarify. I believe at this time there were the green sheets in place that counsel would have signed.
Yes.
So it's not much of an additional burden to ask the additional question. And by the way, does it apply to you, this thing that I'm talking to you about now?
Exactly.
Can I ask you, why do you think that the DIA should be retroactively applied? I mean, your client's case was over 5 years before Padilla came around. Ordinarily, we wouldn't apply a case like that retroactively.
It's true, Your Honor. It was 5 years before, and it would have to be applied retroactively. I just want to note at the onset that this case was argued in front of Judge Miller in the district court. Commonwealth did file a written opposition, and there was not an argument at that time about the retroactivity. The only issue appeared to be, to me at that time, was the first prong, but I would be happy to respond to Your Honor's question as to why it should be applied retroactively.
Sure.
Essentially, Padilla is an application of Strickland. Strickland was 1984. I think Strickland is the default case for ineffective assistance of counsel pursuant to the Sixth Amendment. And there was a variety of cases that have come after Strickland. And individually, case by case, facts of different cases have been applied to Strickland. And in that process, it's an application, and it's not, as the Commonwealth would suggest, a new rule.
But wasn't it fairly uncommon, maybe almost unprecedented, for a court to say, no, immigration consequences are now part of the criminal case? I mean, they had always been, maybe not, the U.S. Supreme Court hadn't opined on that, but hadn't state and federal courts fairly consistently suggested those were collateral issues on which the ineffective assistance of counsel claim did not apply? The courts have, the state courts have said that. I think the language in Padilla, along with some of the prevailing norms, well past Padilla, back to Strickland, I think would suggest otherwise. There are at least two mass appeals court cases that would that do state just that the failure to advise at that time was not of ineffective assistance of counsel, citing Safarian, which was before Strickland, which was 1976, and not speaking particularly to Strickland. However, the language in Padilla, I think, is very important, or is somewhat instructive on that issue, because Padilla states that this is an integral part of the penalty, and it has been for a long time. In fact, they talk about an 1893 case, which goes back to how far back it's been discussed about the severity of the immigration consequences being like a punishment, or in some cases actually worse than a jail sentence. And Padilla also goes on to say that the 1996 changes in the immigration law, which was important on this particular case, but it's important in general. In this case, it made a situation where there's no defense in the immigration court. It's a mandatory removal. This particular one was an aggravated felony. But those changes confirmed their view, is how Padilla termed it. And prior to Padilla, between 1996 and Padilla, had there been any state or federal cases that said it was ineffective not to give immigration advice as part of a criminal representation? As far as you know. I mean,
no, not that I'm aware of. I know that there's been some state cases which have discussed retroactivity and discussed that it's not a new rule, so I'd suggest, I think it's Indiana might be one of the jurisdictions.
Okay.
I know in Massachusetts there's been those two cases, Montero and Frere.
Okay.
Mr. Glenn, how far back would you say we roll it back? How far back? If we apply the Padilla holding retroactively, how far back would we go?
I would suggest, I would say you're on at least to Strickland, because as I said, I believe that Strickland is again the default case on ineffective assistance, Sixth Amendment, United States Supreme Court, and that's what any motion for a new trial is going to be based on, or should be based on, in the district court or the whatever lower court it's in.
Okay, but didn't Padilla speak of changes in the immigration law, which may make this distinction between a direct and collateral consequence diminish and essentially evaporate? So, I mean, wouldn't we have to consider what's appropriate for an attorney in view of the changing consequences of a conviction under the immigration law?
Your Honor, the way I viewed that language in Padilla was more that in these situations, collateral versus direct is not really even a relevant discussion. The way I view the language of...
But they say that in part because of changes in the immigration law, including, I think, the 1996 amendments, I could get the year wrong, which basically made it effectively mandatory for certain convictions to result in deportation. So why would we go back before that change in law?
I think Padilla, the language of Padilla suggests that this has always been the case. In fact, they specifically say they've never made a distinction between direct and collateral. In fact...
They have never, but they recognize that lots of other courts have, that the U.S. Supreme Court has never had occasion to make that distinction.
Right, and then I read their statement that even such a discussion is ill-suited towards these types of...
Yeah, but you're talking about two different, you're using collateral in two different ways here. One is direct and collateral consequence, right? And
Correct.
the other is direct and collateral review of a case, which is, I think, what we're concerned about. Am I missing
Oh,
something?
excuse me, I thought you were talking about the...
No, I was speaking about the collateral consequences as
Yeah.
opposed
You
to
were,
collateral
okay.
review. I mean, the
Right.
Padilla, the U.S. Supreme Court says, essentially, whatever may have been the rule with regard to the collateral consequence, that the attorneys need to evolve as the immigration law changes. And now, in view of, I guess, the not-so-new legislation, if you're convicted of certain crimes, including that which Mr. Padilla was convicted of, you're essentially going to be deported. And it's no longer a question anymore, and that we need to evolve the Strickland standard in view of the changes in the law. Are you saying we should go back before that change in law under immigration, back to 84 when Strickland's decided, or do you recognize that it may end at a later date?
I suggest, Your Honor, that it does go back to Strickland based on the language in Padilla. I think it doesn't. It talks about the 1996 amendments is somewhat explanatory, but I think the language in Padilla clearly, to me at least, Your Honor.
Let's put aside Padilla for a moment. Let's assume you get past Padilla. Let's assume you're right. It is retroactive. Why should we find that it would be of consequence here, since there was an immigration warning given? Your defendant does not state in his affidavit that he would not have pled if he had been told. The defendant was facing school zone charges, which were dropped and ultimately ended up only with 2 months in the House of Correction, 5 months to serve. I mean, he got a very, very good deal. Why should we conclude that it would have been consequential if indeed he had been advised that he was nearly certain to be deported if he were to be convicted?
As far as the good deal, I agree that when you're facing a 2-year mandatory, 3 in the House is going to be much better. But I think a lot of the cases cited by Padilla, in Padilla itself, recognize that sometimes the immigration consequences can be so severe, and actually more severe than a jail sentence.
Sure, but what would have happened in this case? Your client would have gone to trial, gotten a 2-year mandatory, and then been deported. I mean, how could it rationally be argued that he would have insisted on a trial here rather than to take the plea?
Well, first of all, I think that he wouldn't necessarily have gotten convicted at a trial, but I think that there's other ways out of this. And certainly if the knowledge was in the lawyer's head about the aggravated felony nature of this charge, it would open up plea discussions with the DA, because if the police report was included in the record appendix by the Commonwealth, it presents a very strong case for possession, an indefensible case on
Well,
possession.
there was also the question, as I recall from the record, that he was standing around looking nervous, and they used that opportunity to pat frisk him and find the contraband. But beyond that, so you're suggesting that when the package of consequences is not just 3 years, but deportation for life from the country you've lived for, most of your consciousness, right. That's the consequence that then the defendant is entitled to make, to make part of the consideration. Do I do that or go to trial and see what happens, given the facts of my case?
Yes, Your Honor, and even more than that, Do I do that, or do I do some other things, like again, trying to perhaps, this is a good case, I would suggest, for pleading to possession. Now, instead of intent to distribute as part of a plea bargain. Now, possession would change things drastically in the eyes of the immigration court. That there's two different ways a person can be prosecuted for removal on a drug case, and one of them is it involves discretionary relief by the immigration judge. The problem with intent to distribute is an aggravated felony under the Immigration and Nationality Act, and essentially requires removal with no defense other than I was not convicted.
Are you suggesting that if that had been in the table, I mean, basically you're talking, is what you're saying is you would have been able to persuade the prosecutor because of the immigration consequences, you should agree to possession? Is that what you're saying?
Well, it would have been a potential avenue of relief that was not explored. And I don't think he has to show necessarily that he would have gone to trial. I think he has to show that the outcome would have been different.
How is he going to show that?
Well, I think you have to show.
Yeah, he doesn't need to say anything about it in his affidavit.
Yeah.
How is he going to show that? He's got to show it. It's part of the ineffective assistance of counsel claim.
I think from the surrounding circumstances, Your Honor, in all due respect, the affidavit of
a reasonable probability that the outcome would have been different. So you're saying, well, he could have said, please don't make me plead to that. Make me plead to possession. That's what he would have said.
He could have explored that in very
probability that would have happened.
Based on the police report, an indefensible case on possession and a very triable case on intent to distribute.
I'm sorry, how much did he have in his possession? A number of different bags, plus
There's
$1,000
a number
in
of different bags, yeah.
$1,000 in cash.
Yeah.
He had over $1,000 in cash, didn't he?
Yeah.
Was he working at the time? Have any evidence?
17 years old.
He was 17 years old. There was no evidence of a job, but that's not part of the.
A lot of money in his pocket.
Yeah. I agree that there's some evidence of a possibly intent to distribute, but I don't think it's a case that can. Certainly, there's an argument to be made of when you have bags like that, and I think any expert that the Commonwealth has to produce a trial by way of police witness as to what goes on in the street would say, if you want to buy 4 bags, then 4 bags worth, you often have to buy 4 bags. I mean, there's a whole line of defenses that could be gone into, and I don't think he's precluded from raising those. And I think if he was facing mandatory banishment from the United States, and it is banishment, he can't even come back after an aggravated felony, it might be a chance he was willing to take, and I think a chance he probably would have been willing to take. And again, I just want to talk about the affidavit of the defendant. It is a two-edged sword, because if he files an affidavit and rests on his affidavit, the first thing is, and it comes out, and most judges, and the judge in this case would say it's self-serving. I think this is a difficult thing to prove, the prejudice, and I think it is, and I think it needs to be looked at with the surrounding circumstances.
Yeah, you know, counsel, I've allowed you to go way over your time. Your time is up. The blinking red light.
Oh, I'm sorry.
Time's up. That's
Sorry.
okay.
I appreciate
Very
that, Your Honor.
interesting discussion. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Anna Kaluri for the Commonwealth. Before I discuss the retroactivity of Padilla, I'd like to focus on the facts of this case quickly. Under the second prong of Safarian, in the context of a guilty plea, the defendant has to show whether the defendant would not have pled guilty but for the advice. Here there's been no allegation that the defendant would not have pled guilty had he received this advice. And that fact is fatal to the defendant's case, and that goes as far back as Hill v. Lockhart. If he hasn't made a claim, he cannot succeed on this. So regardless of whether or not the Court gets to the retroactivity of Padilla, it would not matter in this case.
If we can move to Padilla now.
Yes.
Why should we consider this to be an open question in view of Padilla? Because we can look to see what the Supreme Court did in Padilla, and under Teague, the Supreme Court says, we're not going to reach the constitutionality of an issue until we decide it's retroactive. And then in Padilla, they reach the issue of whether it is constitutional, whether it's ineffective, and they find that it is, and that case was on collateral review. So if we look to see what the Supreme Court did in Padilla and their discussion of the concern about whether this will open the floodgates, isn't it plain that the U.S. Supreme Court has said that this is retroactive?
No, I don't believe it is, and there's a number of points there. First, they did not address the retroactivity at all in Padilla. And I would suggest that, yes, in Teague it says in a habeas case, they will not apply a new rule unless it applies to everyone who's similarly situated. Padilla is not a Habe case, and it's differently situated. Yes, it is on collateral review, but the only way to review guilty pleas is on collateral review. There's no direct way to review a guilty plea. And so I think it falls into, it's different from a Habe case in the cases that Teague directly addresses with whether or not you apply a new rule, if it fits within the two exceptions. The only way to ever change the law regarding guilty pleas is to apply it to the defendant that's before them. Otherwise, the law wouldn't move forward.
And if you were right, then why you said they don't address it? They discuss the concern about opening the floodgates. They don't say, well, we heard this case only to decide this issue, but we're not going to open the door for retroactive review. That would have addressed the floodgates point, but that's not what the Supreme Court says.
Well, I think the floodgates issue comes up with the concern about the finality of guilty pleas. And it goes back to, I believe, Hill v. Lockhart, too, and that's the same concern there is when you're creating a new rule and another way to vacate guilty pleas, there are going to be numerous cases and challenges, as we've seen, on that ground going forward. And that could be part of the floodgate issue. I think also, too, where the court is specifically not addressed retroactivity of partial or full, whether or not it applies to the people similarly situated or even going backwards, looking at it to find out subjectively what they thought is not the correct way to address this issue. If you look at Teague, it's an objective standard. Did this create a new rule? If it created a new rule, does it fit into one of these two exceptions? And here, yes, I believe it does create a new rule, and no, it does not fit into either of the exceptions.
But you don't think that maybe Padilla is saying that the issue is going to be, the floodgates issue is answered by whether it's prejudice? I mean, you look at each case about whether it's, you really have shown prejudice or not, and it's going to be very hard to show?
Yes, that is one way in terms of when you open up a new way to attack guilty pleas, one way that limits those attacks is obviously the prejudice portion. But I don't think the floodgates issue is dispositive of whether or not it's retroactive or not. And again, I believe it's an objective analysis as to whether or not this was a new rule and whether or not it fits into either of the two exceptions.
So unlike, because guilty pleas are just so different from obviously something that's gone to trial, but presumably you would say then, there could be 500 motions for new trial or whatever may be the procedural vehicle in a particular state, filed the same day as Padilla, but only one got to the Supreme Court and they got rejected. Those people are out of luck, right?
Yes.
But look at the language of Padilla. Padilla says, it seems unlikely that our decision today will have a significant effect on those convictions already obtained as the result of plea bargains, because for the last 15 years this has sort of become one of the norms, and there really are very few challenges in the large scheme of things to guilty pleas because of what you lose. I mean, doesn't that suggest that not to worry, I mean, there won't be a huge flood of folks who have already pled guilty attacking this because there are other issues. But it does suggest that there could be people who attack it. I mean, isn't that what the language says, almost specific?
Yes, it is what the language says. But I still don't think that it means that it's retroactive. Again, it's looking into the subjective intent isn't the way you look at whether or not it's a new rule. And here there could be a variety of reasons as to why. At this point, we don't know what was before them in terms of what the state courts were doing, how they were applying it, how many of these cases were out there. And to a certain extent, it's left to the state courts to kind of figure this out. And so I think looking at the results of Padilla is one thing. that was appropriate for them to do, but I don't believe it mentioning floodgates and the amount of claims that would come as a result of Padilla is a way to extrapolate that this is therefore
Yeah, I mean, it wasn't just mentioning
retroactive.
floodgates. It was specifically saying, we don't think this will have much of effect on convictions already obtained by guilty pleas. In other words, those that you would say would be cut off in any event. But it doesn't say that because they're cut off. It says because there are probably very rare instances or reasonably rare instances where these will be brought.
Yes.
Just should ignore that.
Well, I don't think you should ignore that, but I don't think that in Padilla it has any discussion as to retroactivity. It looks and says, yes, these are ways that they're going to attack the guilty pleas, but I don't think it's dispositive of whether or not it's retroactive.
Okay.
Now, there are a number of cases which have found that it is retroactive. You're aware of those.
Yes, and there are a number of cases that have found it's not. In looking briefly through Lexis, I found that the courts right now in terms of retroactivity are probably split 50-50. There hasn't been any circuit court of appeals that has held or any final state court that has. For the majority, it's usually district courts, federal district courts that have. There have been some, like the Maryland case that I presented in a 16L letter, that have found that it is not retroactive, but I haven't found any sort of prevailing.
Now, why should this not be viewed simply as an application of fact to Strickland? There's, after all, been an evolving set of new statutes regarding immigration which have changed the likelihood that a conviction will result in deportation. And why should Strickland not evolve with changes in the circumstances concerning the law of deportation?
Well, the case announces a new rule if the result was not dictated by precedent existing at the time of the defendant's conviction. And here, precedent did not dictate that this was part of it.
But they also say that an application of fact to an existing rule is not a new rule.
That's true.
So
but
that's the issue. Is this an application of fact to Strickland, or is it a new rule? And
I believe it's a new rule because it's directly contrary to the law that had any appeals court case before this. Obviously, the Supreme Court had not decided this prior to that. So the appeals court cases that had looked at this issue decided that it was collateral. This case goes squarely against it. And the First Circuit had as recently as 2000, and this court has followed that, that immigration consequences were collateral. They were not direct consequences. Something that is changing fact is, for example, the failure of counsel to investigate an alibi defense. Something like that where it's something within the gambit of direct consequences and it is a different factual situation. This is something that's completely collateral, well, before Padilla, to an attorney's duty to his client.
But Padilla sort of goes out of its way to say, we've never held that.
That's true, and that doesn't...
I mean, why would you do that if you were really going to say that you're... Why would the court go out of its way to make that point if it was going to... if it really felt this was a new rule and should only apply in that way?
That statement, I believe, doesn't have much to do with whether or not it's a new rule or not. It just means that they weren't bound by anything. And at that point, the lower courts before that, all of the federal appellate courts that had actually considered this, were directly contrary to the Supreme Court in Padilla. In fact, Padilla cites no case that actually supports its position, all of the other law being flatly contrary. They cite many cases that say that this was a collateral consequence and not a direct consequence, therefore it's not within the gambit of the Sixth Amendment. But there's no cases to the contrary.
Okay, but isn't there, I mean, Strickland essentially speaks of whether or not one is performing in accordance with what a reasonable attorney would perform. And hasn't there been an evolving standard of what a reasonable attorney is to do? And doesn't the Supreme Court make reference to the American Bar Association standards and others which say that it's essential that an attorney confer with his or her attorney about immigration consequences as part of a criminal case? Isn't that a changing factual circumstance which may affect the Strickland analysis?
Perhaps, but it's not simply because it's reasonable and simply because the practices of attorneys are changing in response to the legislation regarding immigration doesn't mean that it is dictated by precedent. And in fact, here, it's flatly contrary to the precedent before it.
That precedent being that it was not previously viewed as ineffective.
Yes.
All right.
And it was previously viewed as something collateral, therefore not within the Sixth Amendment.
Exactly. So while there might be reasons, and good ones, that the Supreme Court had for changing the law, it doesn't change the fact that it did change the law. There are reasons for it to do so, but it still is contrary to the law, and therefore it is a new rule. And it doesn't fit into with either of the two exceptions here. The first one is not applicable here, and the second one is whether or not it's a watershed rule of criminal procedure, and here it simply doesn't fall into any of those exceptions there. It suggests that if Crawford is not, doesn't fall into one of those
Now, going
exceptions.
to your other
then this
point,
can't.
the Supreme Court remanded another case that was also there on collateral review in view of Padilla. Why would they do that if you're right?
Why would they remand another case for review?
Yes.
Well, perhaps going back to Justice Botsford's question about if there's 500 cases before, perhaps my answer to that was incorrect. If they were similarly situated at that time because they had brought this, perhaps they're allowing that. But I would suggest that any case that had not had this issue pending review would not be able to make itself available of this case law. If there are no further questions, I'll rest on my brief.
Thank you, counsel.
Thank you.